So good afternoon, everyone. Thanks for attending. You'll be glad to know this is recorded. Recordings will go out to you. If someone wants to start that as well, it'd be great. So you'll get copies of that. So obviously, this session is one of quite a number of webinars that are organised by Surrey Law Society. So today's one is obviously recognising coercive control with June Ventures, and these on screen now are ones that you register for, but you can go to the SLS website to get more details and register there. So during the webinar, if you can just use the Q&A function to ask questions for June at the end, and if we have time at the end, obviously if you raise your hand, we'll invite you to ask a question directly to her. And again, it's being recorded, the webinar. So before our bit, I'll introduce you. Oh, sorry, I'll do our bit first. I'll keep it brief because June's bit is what you've all come to see. So Evelyn Partners is a really big company that not a lot of people have heard of. We're actually #1 integrated provider of wealth management, online investing and accountancy. So very well integrated into the 3 key areas that typically people have worked in silos. So as a financial planner, I would often have to refer people to an accountant that would be external, and there's no sort of integration there. And in investment wise, again, we'd have to sort of refer people to an off-the-shelf product. But Evelyn Partners are integrated, and we have investment managers that look after client money directly, and we've got in-house tax specialists, audit functions, forensic accountancy for working on things like divorce, etc. So really good long track record of fund performance, and 62 billion just under in assets under management. Similar number of people actually across the board, so 400 plus accountants, nearly 300 financial planners, and just over 300 investment managers. So kind of a good balance between them all, and 30 corporate offices throughout the country. Next slide, please. Thank you. This is something we do quite frequently for clients. Pretty much most opt to have it. It's called cash flow modelling. So it's a financial plan showed in a graphical format. Really useful for things like, when can I retire with the money that I want? How much do I need to put in to achieve the goals I want to? And in what if scenarios, what if a partner dies? And this is used quite commonly when if you're looking at divorce cases and someone's sort of taking some money out from someone else, you can show them what things look like moving forward, because sometimes there's uncertainty. Perhaps they've never dealt with finances before, so it's quite a nice graphical format to show people different scenarios and different outcomes. So basically that's Evelyn Partners. I want to keep my bit short on purpose because apparently the registration is really high. I'm not surprised with June's experience. So you've obviously come to see her, so I'll stop there. Obviously this webinar is designed to deepen your understanding of coercive control and its impact within family dynamics. June will share some real-world examples, discuss relevant legal frameworks, and explore best practices for addressing coercive control in family law cases. And it aims to equip you with the knowledge and tools to recognise and respond to coercive control, ultimately supporting your clients throughout the challenging journey of seeking justice and safety. June's sort of bio here, I've got some certificates behind me, but that's nothing compared to June. So I've looked her up. It's a very impressive CV. So June Ventures KC is a pioneering family lawyer whose career spans 40 years, and her extraordinary blend of professional qualifications, expertise and experience is second to none. June specialises in family law, predominantly working on complex public and private children disputes, often with a criminal element. She's known as a crusader for equality and access to justice, whether that's representing children, mothers or fathers. June remains one of the only few women to have achieved dual qualification as a solicitor and barrister, and she was the first woman solicitor to be made Queen's Counsel back in 2006 and remains one of the few women to achieve this accolade. She is also a part-time judge, which is testament to her skill as a lawyer and advocate. And in 1991, June founded a law firm built on the ethos providing access and justice, and this is very much the ethos of Ventures solicitors to this day. To read more of some of June's more notable cases, please visit her website. So without further ado, I'll hand you over to the headline act.
Well, good afternoon, everybody. First of all, thank you all for joining me. I'm going to share my screen very shortly. The subject I've been asked to talk about is what I consider to be a very broad subject. As you've heard, I've always specialised and continue to specialise in family law and in criminal law. And this topic, it seems to me, is a topic that crosses over both jurisdictions. And so I'm going to be focusing on that. And without further ado, I shall now share my screen. Which at the moment, there we are. Right. I'm going to basically start with the whole concept of coercive and controlling behaviour, and just looking at where it mainly affects in the legal system. As we know, it often affects criminal law, family law, and employment law. I'm not going to touch on employment law, but I will focus on criminal and family law. Before doing that, I thought it would be really helpful to have an understanding of where the concept originated, because it is a fairly, I'm being told you only have a blue screen, is that right?
That's right, June. We can only see a blue screen at the moment.
Right, I'm sharing my screen. Can you see that?
Yeah.
You can?
Yes.
Okay, so you haven't missed anything because I haven't actually started on the slides, so don't worry. So what I thought we would begin with is the history of coercive and controlling behaviour, because it's a concept that has developed in this country relatively recently, but actually it started in America with an American sociologist and forensic social worker, Evan Stark, who introduced the concept to describe psychological and physical dominance by abusers. Now, essentially, as we all know, for many years, we've had the availability of obtaining injunctions for victims of abuse, but in up until recently, that really focused on physical abuse. But Evan Stark and his concept was that coercive control creates invisible chains and a sense of fear that pervades all elements of a victim's life. It works to limit their human rights by depriving them of their liberty and reducing their ability for action. And other experts at that time also basically took the view that coercive control is likened to being a hostage. Now, what was interesting was that in 2002, which is some time ago and a long time before we really began to address it, Evan Stark was the lead witness for 15 women in New York whose children had been placed in care because they had witnessed their mothers being abused in the home. A federal judge ruled in favour of the women, concluding that the city had violated their constitutional rights by separating them from their children. Evan Stark then gave evidence in this country, and basically he gave evidence in the London case, in the case of Sally Challen, who had bludgeoned her husband to death with a hammer. She was released from prison, and he told the court that coercive control is designed to subjugate and dominate and not merely to hurt. So effectively, just looking at what he achieved, he actually introduced into the concept of domestic, what we used to know as violence, domestic abuse, and essentially introduced the concept that it didn't mean that domestic abuse was only physical violence. It also included effectively emotional harm and psychological damage. Now, the concept of coercive control within the English legal justice system, in fact, was not introduced until the Serious Crime Act in 2015. So a long time after Evan Stark had really got to grips with this subject. When looking at the Serious Crime Act, and it was in the criminal jurisdiction, that this concept was first introduced when looking at the criminal jurisdiction. Although we had the Serious Crime Act introducing the concept of coercive control, what it didn't provide for was that if, for example, partners had separated, but the abuse continued, they couldn't be prosecuted. And all of us specialising in the field of domestic abuse are familiar with the fact that when partners separate, very often the abuse continues, and in some cases it can increase. But unfortunately, nothing was really done about that until the Domestic Abuse Act came into force, which I have to say was not until April 2023. And Section 68 redefined the meaning of personally connected. And what that means is that it provided for a criminal offence to be pursued regardless of whether the partners were still living together at that time. And of course, that was a major development in relation to coercion and control. And what I should say is that there has been, during the course of the last year or so, a considerable increase in the amount of prosecutions that are now coming before the courts. Looking at the definition of personally connected, I won't take time to go through this in detail, but you'll be able to refer to it. As you can see, there are a number of situations which in fact govern personally connected. Going on to look at the ingredients of the Serious Crime Act, ultimately it consists of 3 ingredients, where the perpetrator, referred to in the Act as A, repeatedly or continuously engages in behaviour towards another person that is controlling or coercive. The behaviour has a serious effect on B, the victim, and A knows or ought to know that the behaviour will have a serious effect on the victim. And prosecutors are told to be aware that conduct can vary from one person to the other. Where there is uncertainty about the appropriate dynamic of a relationship, and I thought this was quite interesting because the College of Policing authorised professional practice on domestic abuse essentially describes this as an approach when looking at whether or not someone should be pursued for this offence. And what it says is simply this: in many relationships, there are occasions when one person makes a decision on behalf of another, or one partner takes control of a situation and the other has to compromise. Ultimately, that can often be a situation that does not involve coercion and control. The difference on what does create that concept is in an abusive relationship, decisions by a dominant partner can become rules, and when broken, lead to consequences for the victim. Now, ultimately, looking at what one has to prove in order for this crime to be pursued and subsequently a conviction to flow from that, is where the victim is caused to fear violence on at least 2 occasions, or the serious alarm and distress caused by the suspect's behaviour has had a substantial adverse effect on the victim's usual day-to-day activities. And again, prosecutors are expected to assess the impact on the victim by recognising the cumulative impact of a pattern of abuse. It's important to recognise that there is a statutory guidance framework which outlines a non-exhaustive list of the types of evidence that can be provided. And for those of us who represent clients in court, whether it's in the family court or in the criminal court, we are seeing, and certainly as I'm sitting in the Crown Court, I'm seeing an absolute increase in evidence amounting to phone records, emails, smart doorbells, GPS tracking devices, and so on. And I think it's very, very important when we are representing clients who are pursuing this, either during the family courts or if they're coming to us for advice in relation to a potential criminal prosecution that they're involved in. It's really important that we actually go through with them the types of evidence that they need to think about and produce if it's available, because so much can be determined from emails and text messages. They are absolutely crucial now pieces of evidence. The Serious Crime Act offence can be tried in the Magistrates' Court or the Crown Court. The maximum penalty for that is 5 years, and depending on the starting point and category range, it can vary between a low community order to a term of imprisonment up to the maximum. And obviously, as with any criminal offence, in determining the appropriate sentence, the court will always look at aggravating factors. What makes the situation worse? For example, has the person been in trouble before? What effect has it had on the victim? Mitigating factors. Obviously, if the person is perhaps suffering from anxiety, depression, that may mitigate matters if they've never been in trouble before. And also, if they have pleaded guilty to this offence, then they will be entitled to a reduction in their sentence. The important thing, it seems to me, when we are advising clients is that they ought to know that there is a criminal route that they can pursue, as well as a civil route. And as I say, I haven't focused on injunctions in this seminar because this is more about the broad concept of controlling and coercive behaviour. But ultimately, the clients who come to us for advice, in my view, ought to know that there is a choice, that they can pursue matters through the criminal jurisdiction by reporting it to the police, and equally they can pursue a civil dispute. I think it's also important to be aware of the domestic violence protection notices and domestic violence protection orders. And I should say these are due to change in the relatively near future. They are going to have wider powers and longer sentences. But what we have in place at the moment, introduced by the Crime and Security Act of 2010, which didn't come into force until 2014. So just looking at that, when do the police use these measures? So ultimately, this is not pursuing them under the Serious Crime Act for an offence, but this is nonetheless the police taking action against someone accused of coercive controlling behaviour. So the police will take measures of this description when they are not taking other enforceable action. For example, they may have arrested somebody and they may have decided, applying the Code of Crown Prosecutors, that there is not a likelihood of conviction for a variety of reasons, or they may have simply cautioned the suspect with no bail conditions. So looking firstly at the domestic violence protection notices, there's a police power to provide immediate protection to the victim against the offender aged 18 or over. The police must have reasonable grounds for believing the offender has been violent or threatened violence towards the victim, and it must be necessary to protect the victim. But of course, this also encompasses coercive and controlling behaviour. The domestic violence protection orders provide the police and magistrates with the power to enforce non-molestation of the victim, stop the offender from contacting the victim, prevent the offender from evicting or excluding the victim from their household, remove the offender from their household, or prevent the offender from returning to their household for up to 28 days. When going through the courts in relation to these types of orders, the standard of proof is the balance of probabilities. The offender must have been violent or threatened violence, and the order is necessary to protect the victim. Notably, the order does not require the victim's consent. And as you can appreciate, this is because on many occasions, for a variety of reasons, victims often don't pursue matters that they have, in fact, reported to the police. These orders last for no fewer than 14 days and no more than 28 days. So just pausing there before I go on to the next slide. The issue obviously is a concern in relation to the duration, because 28 days may well not be enough so far as a victim is concerned. And therefore, when looking at whether we should be invoking the civil jurisdiction in order to perhaps obtain an injunction, and as we all know, in a situation like that, very often legal aid will be available, but we nonetheless have to justify taking action and spending public money. Well, again, 28 days, even if one of these orders is in place, is often not going to be sufficient. It's a good holding position, but going forward, very often, much longer is required in order to protect the victim. And so the fact that someone has obtained a domestic violence prevention order, in my view, shouldn't prohibit us from going forward in relation to the civil jurisdiction and obtaining an injunction. Looking at the breach of both of these types of notice and order, if a PC has reasonable grounds for believing there has been a breach, they can arrest and bring someone before the magistrate's court within 24 hours to hear the application. Breach of such an order is a civil contempt of court. It's punishable by a fine or up to 2 months imprisonment. And as you heard me say a moment ago, this will be replaced in due course, and the powers and the sentencing will be broadened. We then need to look at the Domestic Abuse Act of 2021. This came into force because its aim was to raise awareness of domestic abuse and to improve the effectiveness of the justice system by providing protection for victims and bringing perpetrators to justice. The Domestic Abuse Act, most of us will be familiar with. I haven't listed everything that it provides for, but in the context of what I'm talking about today, the relevance of the Act is that it creates a statutory definition of domestic abuse, which is not confined to physical violence. It established a domestic abuse commissioner. As I said, it's going to widen the scope of the domestic abuse protection notices and orders. It clarifies circumstances when a court can make a barring order, which is section 9114 of the Children Act, to prevent family proceedings that can further traumatise victims. And just pausing there, I don't know if any of you have in recent times had Children Act proceedings where in fact you have sought to rely on the Domestic Abuse Act in demonstrating the need for a barring order, because there is absolutely no question. And I can cite you examples that I have now, where very often the whole scope of going to court and the actions that a perpetrator takes in bringing someone to court and pursuing them through the court can in itself be abusive and intentionally abusive. And ultimately, this, I think, is a very helpful introduction because the barring order has now been effectively extended, and it's no longer as difficult as it used to be in obtaining a barring order. But as with everything that we seek to achieve through the courts, before making such an application, we need to be very, very clear what action we are saying amounts to coercive control and is abusive, and also what impact it is having on our client. And of course, we can often achieve that by obtaining medical evidence. The Act also extends controlling or coercive behaviour to cover post-separation abuse. Again, so very, very important. It prevents GPs and other health professionals in general practice from charging a victim of domestic abuse for the letter of support for legal aid. And the other three main issues relevant to this seminar is that it prohibits perpetrators from cross-examining victims. It creates a statutory presumption for special measures, which of course all of us now are familiar with, and with vulnerable training and so on. And it places a duty on the local authority to provide accommodation-based support for victims of domestic abuse and their children. And again, for those of us who also practice in the field of public law, it's important to have this at your fingertips and to remind the local authority of their need to provide accommodation for victims of domestic abuse and their children. And just going back for a moment to what I referred to at the beginning with Evan Stark and the evidence he gave to the court in New York about 15 mothers having their children removed because they had witnessed abuse. And as we know, the federal judge there took the view that that was a very wrong decision. Ultimately, we need, I think, to remind local authorities if they are on the verge of issuing, for example, care proceedings on the grounds of domestic abuse and domestic violence, that they are obliged to provide accommodation and to remind them of, in fact, the Act and what it says in relation to that. The Domestic Abuse Act does not create a specific offence of domestic abuse. Any number of offences could fall within the definition. And again, it's important to know effectively what that means. By this Act and by the definition now of coercive controlling behaviour, the prosecutors are all now trained to advise in relation to looking at the substantive offence, which could be, for example, assault, could be rape, it could be sexual, but then looking at it with a view to determining whether there is a domestic abuse element to it. And that effectively is what this Act has provided for. The definition is in section 13C. It created a statutory definition of domestic abuse, which, as I say, encompasses a range of abusive behaviours. And it doesn't matter whether the behaviour consisted of a single incident, contrary to the Serious Crime Act, or a course of conduct. And it can amount to physical or sexual abuse, violent or threatening behaviour, controlling or coercive behaviour, economic abuse, psychological, emotional, or other abuse. And it's interesting to note that the definition of economic abuse is that it is having a substantial adverse effect on the victim's ability to acquire, to use or maintain money or other property or obtain goods or services. What the Domestic Abuse Act 2021 did do was effectively introduce the concept of no defence in relation to the offence of sexual gratification. And that's section 71 of the Act, which came into force in April 2021. So it is now no longer possible to consent to infliction of serious harm for the purpose of sexual gratification, and you cannot consent to your own death. Now, that may sound somewhat bizarre, but I can tell you that I have certainly been involved over the years in cases where that has been raised as a defence. And there was a fairly infamous case that came before Camberwell Green Magistrates Court many years ago. It was a case of Brown, where there were something like 15 defendants. And ultimately, that was the defence that they raised. And ultimately, very often, those defences succeeded, but no longer. Sentencing domestic abuse cases, I thought it would just be helpful to know, and most of you I'm sure will know that the Sentencing Council is the guide that all judges and magistrates have to use when determining the appropriate sentence. It's important to know that there is no specific offence of domestic abuse. It's a general term describing a range of violent and or controlling or coercive behaviour. And many criminal offences can involve domestic abuse. And where they do, the court should ensure that the sentence reflects that an offence has been committed within that context. And I can certainly tell you, as I explained a moment ago, that really does address aggravating circumstances. And it is something now that is brought into all sentencing exercises if there has been an element of domestic abuse. I think it's also important to know, and for clients to know, that the court also has powers on acquittal, for example, Protection from Harassment Act of 1997. So even if a defendant is acquitted, if the court considers it necessary to do so to protect a person from harassment by the defendant, the court can, of its own doing, make an order prohibiting the defendant from doing anything described in the order. And it can have effect for a specified period or until further order. And if breached, maximum sentence is 5 years custody. So just to summarise the criminal law, we have the Serious Crime Act of 2015, which creates the offence of coercive controlling behaviour. The Domestic Abuse Act of 2021, which does not create a specific offence, but ultimately has created a definition which needs to be applied when looking at substantive offences and when determining whether domestic abuse formed part of it. So moving on to the family law jurisdiction now, and very briefly, looking at the various case law. Now, what I have done, and I thought this case was particularly important, because it's a very recent case. I appreciate it's a Northern Ireland family division case, and therefore it's persuasive only. But I thought it's important to look at this case because there is a very helpful discussion in it about coercive control and its evolution within the family division within England and Wales. There's some very helpful extracts. I've just put some of these in the slides. I won't read all of it to you, but I've given you the paragraph numbers. And ultimately, in this particular comment, the determination of whether coercive control has taken place is not a simple task. Well, we all, I think, can recognise that. It goes on to say the subtle and persistent patterns of behaviour involved in coercive control may be difficult to recognise. It goes on to say, which is why I wanted to refer to this extract, that solicitors, counsel and the judiciary all need to develop diagnostic skills to recognise what is and what is not coercive control. And in a few moments, I will come to what I think are practical tips that I certainly think are worth noting. I thought paragraph 84 was particularly helpful because what the master, who is effectively the equivalent, the cases he deals with in Northern Ireland is equivalent to a High Court judge. What he was basically saying was that just because, for example, a patient visits a doctor and gives them a list of symptoms doesn't necessarily mean the doctor's able to diagnose what is wrong with them. And he went on to say, the introduction of the concept of coercive control requires a new way of seeing, but that potentially leads to the problem that if legal representatives cannot recognise coercive control in what the client has told them, then they will not be able to present to the court what they do not themselves see. This will affect both the affidavit evidence and the oral evidence offered to the court, each of which are filtered through the understanding and skills of the legal representative. What I will say, just pausing there very briefly, I'll give you a very practical example of what happened to me some time ago in Reigate, when we had a court there. It was a civil court. And I can remember taking a young lady to see the district judge in order to obtain an injunction. And this was a young lady that had visited our offices for something like 3 or 4 times. She really needed support, encouragement to take action against her husband. And much of what her husband was doing was effectively coercive, controlling behaviour. And of course, this was some time ago, so the criminal jurisdiction didn't provide for that, and the family jurisdiction certainly didn't seem to recognise it at all. And this was demonstrated to me by how the judge approached it. I had drafted her statement setting out how she had been terrorised in a car driven by her husband because he had exercised road rage in front of her and then had effectively controlled whether she could get out of the car and so on and so forth. And I can remember the district judge looking at me, and this is something I have never forgotten, and he said to me, "How on earth do you think that amounts to domestic violence?" Because that was the term we used to use. And he went on to say to me, "I often behave like that with my wife. This is utter rubbish." Needless to say, my response to him was to say I'd be delighted to represent his wife in the future. I never got that opportunity, but equally, fortunately, he didn't stay in Reigate very long, and I never know what happened to him. But that was the approach in days gone by of coercive and controlling behaviour. It simply wasn't recognised. Going on, looking again at G&G, paragraph 86, the Equal Treatment Bench Book, the key work of reference published by the Judicial College. I'm not going to read that out to you. You can see that for yourself, but that gives you the definition that judges now, I'm glad to say, are or have to, in fact, be familiar with. So moving on, again, paragraph 87 referred to the case of Re H and N and others, which I'm sure most of us are familiar with. It was domestic abuse and finding of fact hearings. And ultimately, paragraph 87 reaffirmed that we no longer need to prove physical injury. And that, of course, is a very important development. Paragraph 88, the case of F&M 2021, Mr. Justice Hayden. We think that was the first time that a court was asked to analyse allegations of controlling and coercive behaviour. And he went on to say, at risk of labouring the point too heavily, it is crucial to evaluate individual incidents in the context of the wider forensic landscape. And again, referring, this is paragraph 89, to Re H and N, as we know, most of us, that was clear that ultimately we need to be looking for a pattern of coercive controlling behaviour. So looking at what are the key factors of coercive and controlling behaviour, it's not a single incident. It is a pattern of behaviour, either continuing or a pattern of acts. Its purpose is to exert power, control or coercion, and it's a range of behaviour. Its aim is to make someone subordinate and or dependent by isolating them from support, exploiting their resources, deprivation of independence, resistance and escape, and regulating their everyday behaviour. I've gone on to look briefly at fact-finding hearings in the family courts. This to me really is for another topic. It's a very important topic. We are seeing in the family courts, and I don't know if you would all agree with me, but we are seeing a great resistance to fact-finding hearings being listed. And ultimately, I think that that will come back to bite us all. But how to approach a fact-finding hearing, I thought this might be helpful. So if I just go back to that slide, I hope this will act as an aid memoir and that it will be helpful for you. So what I'm saying is, if you are seeking a finding of fact hearing, so at the preliminary hearing, the court will expect a description in short terms of the overall experience of being in a relationship with the other party. At this stage, the court will have the C1A and response. I think as lawyers, we must be prepared to address the court orally as to what is alleged, or in your position statements, as to what is alleged and the impact of alleged abuse on the parent and the child. We also need, if coercive and or controlling behaviour is alleged, it is particularly important that detailed instructions are taken in advance of that preliminary hearing. It's important to ask the right questions, as victims may not recognise that certain behaviours are abusive. And I've given you at the end of these slides the various tools and guidance used by CAFCASS, including a tool for assessing coercive control and the DASH checklist and the Domestic Abuse Act statutory guidance, which are all useful to assist practitioners in understanding and recognising controlling behaviour. Clearly, you need to detail in your submissions how the disputed allegations are directly relevant to the child's welfare, highlighting the necessity and proportionality of determining the disputed allegations, and the impact of the alleged abuse on the parent and the child is important. And I say that because Mrs. Justice Leven, to some extent, I think Lord Justice Baker has in fact further defined it, but Mrs. Justice Leven has made it very, very clear that if the behaviour that we are complaining about in the family courts doesn't impact on the outcome for the child, the welfare outcome, then there need not be a fact-finding hearing. So it is really, really important, it seems to me, that the moment we meet with a client, we need to have a real understanding of what they are complaining about, what experiences they've had, and why we say it is relevant in relation to the children for the outcome of the family dispute, which usually is Children Act proceedings, and also on the victim, which is usually the parent who has care of the child. And again, as I say, that is very important to get to grips with at the outset. On the other hand, if you're trying to oppose a fact-finding hearing, which you may be, I've given you some tips as to what I think would be helpful. So you need to ensure a response to the C1A is filed in advance of the preliminary hearing. Consider whether the alleged behaviour amounts to domestic abuse, and refer to the definitions in the Practice Direction 12J, 2A and 3. Consider whether the alleged behaviour in fact amounts to bad behaviour rather than domestic abuse, and look to paragraph 32 of Re H&N, which describes that for you. And whether the behaviour complained of is because of the breakdown of the relationship rather than the cause of the breakdown. It's also, if you're opposing a fact-finding hearing, I think the case of K&K is very helpful because it's a useful case to cite to remind the court that a finding of fact hearing is not necessary in every case. Be clear in your submissions as to how it is said the allegations are not in fact relevant to the child's future welfare, and determination of the same is not necessary to make final welfare decisions. So the converse to what you would be arguing if you were arguing for a fact-finding hearing. I've given you examples of coercive control. This is women's aid. This is the definition. And as we can see, there is a long list, but it is not, in my view, exhaustive. There are many, many other types of coercive and controlling behaviour. When it comes to representing victims of domestic abuse, what I'm suggesting is you need to be alive to how long it can often take for a victim to seek advice and representation. And I go back to my Reigate case. How a victim may be reluctant to take action for fear of consequences and or repercussions. Always remember there are no typical victims, and as indeed we have to do when directing juries, avoid assumptions. It's very, very easy to draw assumptions. If someone is sitting in front of you and they don't seem too distressed, it could be an assumption that perhaps it's not as bad as they are making out. But again, we have to be alive to the fact that emotions do not always surface on the outside. I thought it would be helpful to look at helpful questions to explore with the client complaining of domestic abuse. And this is what the College of Policing recommends. So if police officers are called to investigate a domestic abuse allegation, they are specifically required to ask these questions. So whether the victim is subject to rules, if the victim is involved in making decisions. And again, that's to me a fairly obscure question. You need to actually think outside the box and say, well, what would we be asking the client? And it can be as simple as, effectively, in your home, who would you say makes decisions? Now, your client may simply say, well, you know, most of the time it's me or it's my husband, but ask specific questions. For example, okay, well, who decides who's going to watch what programmes on the television? Who decides what you're going to have for dinner? Who decides where the children are going to go for school? Actually sit down and work out some specific questions, because those answers can be very, very telling. And if the victim's daily activity is controlled or monitored by the perpetrator, for example, you know, when you go out, does he call you? Does he text you? How often? What does he say? You also want to know what the behaviour has on your client's daily activity and so on. So you can go through those questions, but my advice in relation to them is think outside the box, think of questions that arise from those headlines, and perhaps have a checklist that you can go through with your client. And then looking at signposting, all that I've done here is effectively give you some signposting that I think is helpful. Women's Aid, a pioneer for the introduction in the English legal system of the concept of coercive controlling behaviour, and a pioneer for the introduction of this in the criminal jurisdiction. But there are other organisations as well, and I think it's helpful to have those phone numbers and their websites available to signpost clients. Also, always remember that men are also subject to domestic abuse. And whilst we know statistically there are more women than men who are subject to domestic abuse, I'm not entirely satisfied that the margin that we see from those statistics accurately reflects the reality on the ground. Because it does seem to me, from the experience I have in representing men who have been in a domestic abusive situation, that often they are enormously reluctant to complain, to seek help, they almost feel that it's humiliating. Now, we know all domestic abuse victims are very often very reluctant to come forward, but I think there is a difference between men and women. They have their own reasons and so on, but I think we should never overlook the fact that men also are victims of domestic abuse. I've given you what I think is the relevant legislation and guidance that will help you in looking at this topic in a much broader sense. And as I say, that goes over to that last slide. And I think this is one to remember at the moment with regard to fact-finding hearings and domestic abuse in private law children proceedings, because that gives you the guidance that the courts are referring to and the tests in the sense that you are going to need to meet if you're going to satisfy the court that a fact-finding hearing is necessary. All right, well, I said I'd finish at 1:20. It is 1:20, so I'm going to come out of that and stop sharing my screen. And basically ask if anyone does have any questions that they would like to raise. I'm very happy to deal with them now. Equally, if you want to email and I'll deal with them later, please feel free to do so. And I think that emails can be sent to the Law Society, Surrey Law Society. Matt, you're on mute.
Sorry, yeah. Do we have any questions at all? I've had a look in the Q&A. Can't see anything in there at the moment. Has anyone got any questions for Jean, please? No. You can put your hand up if you want to on the Teams. You can click up, raise your hand if you want to ask anything.
All right, let me ask a question. Would, so far as this topic is concerned, would you feel that it would be helpful to address specifically the Family Law Act in broader terms and injunctions? Does anyone want to let me know if they think that?
Anybody?
No.
No. You can put a thumbs up if you want to. If you don't want to speak up, you can just click the thumb. Yes, there we go. We've got Emily. Brilliant. Thank you, Emily.
Okay.
So we've got one. We've got a yes for that.
Okay. Can I ask a question then again? Does anyone in relation to dealing with clients who are coming to them complaining of domestic abuse, do you have effectively a list of questions going through the types of coercive control, for example, that the College of Policing are doing? Is that something that everybody does, or is that something that you think would be helpful?
Yeah. That's a yes from Gemma. Thank you, Gemma.
All right. And so far as fact-finding hearings are concerned, is that something that everyone is experiencing now? Courts are reluctant to deal with, or is this in some parts of the country? For example, I go to the north sometimes, and I also practice in the south. We are finding in the north at the moment that they are coming down quite heavily against fact-finding hearings. Is that something that everyone else is experiencing, or is it mainly what I'm experiencing in the north?
We've got a hand up from Amber. I think Amber wants to say so or ask something. Don't know how we get hold of Amber. She's there, but Eloise,
Hello.
there we go. Oh, yeah.
Hi there. Sorry, my mic was I couldn't access it for a bit. But yeah,
okay.
I've experienced that as well. I think there are less fact findings, definitely with some of our clients anyway.
And I mean, how are you dealing with that? Bearing in mind it seems to me that providing you can demonstrate that it's going to have an outcome on the welfare decision that has to be made, are you dealing with it in that way, and are judges receptive to that?
Oh, you're muting again, Amber, I think. I can't unmute her. She's gone.
I think her mic should be enabled, Matt. It's just if she could unmute herself if she is able.
Okay. Amber, do you want to come back? No. Oh, she's gone. Yeah, Justin's just saying, sorry, Justine, an excellent talk, and your highlighting the particular guidance, etc., would be very helpful in practice. Thank you very much. Thank you. Yeah. Anyone else got any questions, or have you got any sort of final, got a couple of minutes left, June? Any other pearls of wisdom or things I know it's only like 2 minutes left, but.
No, I mean, all I would say is that as we know, since the pandemic, the courts are swelling at the seams. We're always now being told, understandably, to look at alternative dispute resolution, and I very much support that. I sit as an arbitrator and I'm a mediator, but I draw the line when it comes to some cases which, in my view, are simply not appropriate for alternative dispute resolution, such as mediation. And I say that knowing that we as mediators can conduct mediations where domestic abuse is involved, but ultimately where you are requiring an investigation to be conducted into the truth or otherwise of very serious allegations, it seems to me that the only forum that we have is the court. And I think, and I firmly believe as lawyers, that we need to continue to promote that, whilst recognising the guidance from the Court of Appeal that it has to be proportionate and necessary. And I'm not suggesting we go behind the Court of Appeal, but nonetheless, we need to put our cases together where it is necessary in order to hopefully argue that successfully. But it is at the moment a real argument that we have to advance.
Great. Brilliant. Well, thank you, Jean. That was really good. I learned quite a lot there. A lot of it was beyond my knowledge as a financial planner, but it was amazing. And that attitude you said about the your previous experience of the the sort of the old fuddy-duddy judge kind of, and his misogynistic attitude. Hopefully, do you see that changing? I know we're running out of time. Do you see that sort of generically changing across the board?
Yes, and I think it's always dangerous, isn't it, to generalise. I should add, he wasn't that young. He wasn't that old, rather. He was quite
sorry.
young.
Okay, yeah, makes it, yeah.
But I mean, ultimately, I think society has changed, thankfully, so we do have greater understanding. But I still think that there's a lot that we have to learn. And as with every situation, we also have to be alive to knowing when it isn't coercive and controlling behaviour. And as with everything, you will sometimes get the situation where a parent will seek to rely on that in order to achieve the end that they want to achieve, which is usually to prevent any contact from taking place with the child and the other parent. So we have to be alive to what really is coercive controlling behaviour and what isn't. And that's why it is so important, it seems to me, that we really need to understand what the concept means.
And have you seen a sort of bit of a paradigm shift in men coming forward now, or making themselves at least, open to they are being controlled? Because obviously, I guess there was this sort of stigma before, wasn't there? It was I'm a man, I can't be anything bad can't happen to me. So is that evolving, do you think?
I had a case within the last 12 months where I have to say the police and their approach to it really wasn't as they should have been. And it took an enormous amount of time to persuade the police that the man actually was the victim.
Right.
So I think we've made enormous strides, but I still think there is more to do. And I think the danger is, and I've always been very clear about this, the danger is that the situation has to be properly and fairly assessed. And again, we shouldn't make assumptions that it's always the woman that is the victim. Very often they are, but not always. And I think that is what concerns me, that there does, it seemed to me, sometimes be a tendency with the police now to be focusing on women as victims and men as perpetrators. So I'd like to see a little bit of the redress of that.
Okay, thank you. Just a quick note to say, because people are dropping off now, you will get a recording sent through in the next few days, and can you please do the feedback survey as well that comes along with the email. Yeah, thank you. So yeah, so it's interesting, June, as a in our world as well, we've got a lot of vulnerable client things now are coming through, a lot more, on sort of vulnerabilities and how it's changed. I think there's a lot more. Do you think there's more? You said it's a massive subject now, didn't you? At the start, when people were offline, you said to us, Helen and Eloise and me, it's now such a massive thing to run through, whereas before, what was the terminology? It was abusive.
It was domestic violence.
Yeah, and now it's transitioned, doesn't it, into
it's
sort
domestic
of mental
abuse. And as I say, domestic violence, and I go back many years. I mean, my mother was in the law, and she was, often in court with clients for injunctions. But it was always violence. And, well, did he bruise you? Have you got any injuries? Have we got photographs of the injuries? But, quite honestly, as my daughter said to me, which is absolutely right, I was talking to her about this seminar yesterday, and she said, Mum, physical injuries heal very often, but emotional scars don't. And what she did say to me, which was very interesting, which shows how society is moving towards change. She's recently had a baby, and when she went to one of the before she had a baby, she went to see the midwives and so on. When she went into the ladies and to give a sample, at the bottom of that bottle was a sticker which you could put on the bottle if you were the victim of domestic abuse. So you didn't say anything. Wow. But they had, in the ladies' toilet, they had stickers that you could put on that sample bottle and hand back to the nurse without saying a word. And that would tell the nurse you were alleging that you were a victim of domestic abuse, and they would then look into it for you. So, because often, of course, the perpetrator would be there when you came back in the room, so you couldn't say anything.
Yeah.
But that's, that's a way forward. And I think the health service has moved tremendously. Pharmacies, believe it or not, have been a part of moving it forward, because they have a code word that some pharmacies now say you can use, and you can look on the internet to see which pharmacy is part of that program. But the victim can go into the pharmacy and use a code word, even though they're with their perpetrator, and they will then take action. So I think the health service has come on in droves. I think the police is trying, and I think the guidance and the rules are good, but on the ground, I think there still needs a lot of improvement.
Yeah. Do you think it's a sort of an attitude of the police as well? Again, the sort of typically a male-dominated environment where, again, it's bravado. And my wife's actually an ex-police sergeant, so and she said a lot of the things you've said I picked up on today was things that she sort of picked up on. And sometimes you say, do you need help? And the person being abused was so abused, they'd say, no, he's lovely and I love him, and that's awful. But Obviously, some of the houses she were in were very low income. So,
Yeah, well, it's difficult. I mean, my own grandfather was a police officer, and I can remember many years ago, when I was a little girl, talking to him, and he said to me, always remember, he said, you never come between man and wife. And in those days, and we're talking in the 1930s, 40s, 50s, you get a phone call to say there's, you know, a domestic dispute. The police officer would go the long way round.
Yeah.
They wouldn't interfere if they could avoid it.
Yeah. Crazy. I'm just conscious of time. Helen and Eloise, I mean, do you want to kind of wrap up, or we?
Yes, thank you, Matt.
I could talk to June forever, basically. She's amazing.
Can I just say one thing? And I know a lot of people have gone, but there is a book that I really recommend. A, it's fascinating reading, and B, it's extremely informative, and it's called In Control: Dangerous Relationships and How They End in Murder. And it's Jane Monckton Smith is the author. She was a police officer. She's a now criminologist, and has been very heavily involved in government initiatives and so on. It's an absolutely amazing read. So if anybody is interested, it's In Control: Dangerous Relationships and How They End in Murder, Jane Monckton Smith.
Lovely, thank you. Let's go on my reading list for sure.
And thank you, Matt. I think we probably ought to bring it to a close now that we're at 1:37, and I'm sure people are desperate to get off for their lunch. But thank you very much for such an excellent session, and we will send the recording round along with a request for feedback. So please do fill that in, and if you could jot down on it anything that perhaps we could ask June to cover for us that she's mentioned today in further detail, that would be ever so helpful. So thank you very much, June, and thank you, Matt and Evelyn, for sponsoring. And we'll hopefully see you soon. Have a great day.
Take care. Cheers.
Thank you. Bye-bye.